All right, welcome debtors and borrowers to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. My name is Matt Burkus. I'm a Colorado-based bankruptcy and student loan relief attorney, and today we're tackling the pesky issue of joint consolidated student loans. However, there is a new law with bringing new hope and a new fix to these pesky loans. So what are joint consolidated student loans? Well, back in the 90s, they started this program where married couples could take each of their student loans and consolidate them into one joint loan. And what that did is created what we call joint and several liability of each spouse for the entire balance of the combined student loans. Now, maybe that seemed like a good idea at the time, and maybe some spouses got through it, but it got messy really quickly, especially when spouses started separating and divorcing, because there's no way to separate those loans, right? So if you get a divorce with joint consolidated student loans, both spouses are still equally liable to the lender for the full amount, regardless of whatever the separation agreement says, whatever the divorce decree says, however it allocates the debt. That doesn't bind the lender. That's just between the spouses. So it got messy really quick, and so they eventually terminated this program around 2006. But they never really fixed any of the problem. But as of October 2022, Congress passed a law to finally allow spouses to separate those joint consolidated federal student loans. And the process is pretty straightforward. It's October 31st, 2022, as I'm recording this video, and that's the effective date of the law. And there'll be a portal and an application coming pretty soon from the Department of Education that'll filter through the servicers that'll allow you to do that. But keep your eye on studentaid.gov, which is the official Department of Education student loan website, for when that application becomes available. But let's talk about how it's going to work. So first off, you have to have one of these joint consolidated federal student loans. And that means and the only way you have one of those is if you were married. You had to be married in order to qualify to get these. So this is going to only be for either spouses or divorced couples who had these loans, who had these joint consolidated loans, and still have them even though they're divorced. Now, ideally, both spouses will apply, and the most straightforward application process is going to be a joint application. So hopefully both spouses will get on board with the idea of doing this, and you can make a joint application for the debt. However, there are some exceptions to applying jointly, and there's basically three of them. The first is if one of the spouses will have to attest to one of these scenarios. Either A, that they were a victim of domestic violence. Number two is they experienced some sort of economic abuse. This is in relation to the Violence Against Women Act. Or three, that they're just unable to reasonably reach or access the loan information of the other spouse. So you will have the opportunity, if you're not in touch with the other spouse and you don't have any of the information, you can still apply to have the loan separated, and the Department of Education will still consider that application. You'll just have to attest that, I don't have the information, the guy or the woman is long since gone, whatever the case may be. So there's three exceptions to doing a joint application, but a joint application is preferred. All right, so how are the loans going to be divided? Well, there's two mechanisms that this new law provides. So first is a proportional distribution based on the original proportion of student loan that was consolidated. So for example, if the original consolidated loan was $100,000, and let's say the husband had $60,000 and the wife had $40,000, well, you're going to have a 60-40 split. And so that's how they'll split up the student loans, or that's how they'll separate the joint consolidated student loan today. They'll do a 60-40 split of the existing outstanding balance. The other option is for divorced or separated couples, is that the Department of Education will allow you to use whatever separation of the debt was included in the divorce decree or separation agreement. And that may be a big windfall for one or the other spouse there, because a lot of times in these divorce decrees, they allocate all the debt to one or the other spouse. There's usually not a proportional split. So if you're one of these spouses who had one of these joint consolidated loans and the divorce decree said, hey, the ex-husband is going to be liable for 100% of the student loans, well, ostensibly you should be able to separate the loans, and the spouse with 0% allocation in the divorce decree will have the loans completely wiped out as to her, and the husband will be stuck with the 100%. Now, don't shoot the messenger on that issue. But this has been a lingering problem for quite some time, because there's just really no options, or there hasn't been really any options for these joint consolidated student loans, and certainly no option to separate them. And when the couples aren't agreeing, most of the time these loans end up in default, and someone's having their student loans, having their tax refunds intercepted or their wage garnishment, and there's not a whole lot they can really do about it. But now finally Congress has passed a law and the president has signed it, allowing separation to take place, and it's going to be a relatively simple application process that hopefully you can do jointly. If not, there's 3 exceptions to doing a joint application to get these joint consolidated loans separated. Best of luck to you. My name is Matt Burkus. Again, I'm a Colorado-based bankruptcy and student loan relief attorney. Have a great week.